Please, Your Lordship. Lordship, I beg to mention item number 8. Item 8, Your Lordship.
Item
8. Lordship, senior counsel is on sanction leave, Your Lordship.
No objection.
on prayer made by the petitioner, not objected to by the respondent. That is adjourned. This is same after 2 weeks.
2 weeks.
Hello.
Please, Your Lordship. Lordship, I beg to mention item number 10, 11 and 12.
Why?
Pray for 2 weeks' time, Your Lordship, as conducting counsel is on leave, Your Lordship.
On prayer made by the respondent. How many respondents are there?
I'm for 10, 11 and 12.
You are for respondent? Only one.
One respondent.
Prayer made by respondent. Excuse me. Not objected to by petitioner. That is adjourned. This is the same after 1 week.
Obliged, Your Lordship.
Same. Tahadu 13. No?
Yes, item number 1.
We are yet to obtain the order, my lord, in this matter, my lord. So, my lord, I'm praying for some more time in this matter, my lord. Next week, my lord.
You're just to seek instruction.
My lord.
It's not a question of opting. You just have to inquire and
My
know.
lord, we have applied for the copy of this order, my lord. So, we are...
What, according to you, what is the information that you have received?
My lord, the bail has been granted, my lord, but we have not seen the order, my lord, till date. So, my lord, fix it next week, my lord, Tuesday, my lord.
Prayer made by Ms. R. Datta, letter counsel for the petitioner. Seeking some more time to seek proper instructions in this regard. Matters adjourned. This is same on Tuesday.
Tuesday.
Same on 4th.
Item 2. Connected, my lord. Item 2.
Item number 3.
Pass over a little later.
Item number 4.
Oh, 5.
Lord, in this matter, Dr. Moska is leading in this matter. He's before the division bench. Lord, these two bail applications, anticipatory bail applications, pertain to that Khanapara case, my lord. Lordships will recollect. My lord, regarding the Bagmara cases, those two applications are listed tomorrow. So, my lord, since all these are interconnected, if this can come up tomorrow along with those, my lord, because they're all interconnected, my lord.
Because I have the status report, my lord, and the
Subject to your lordship's convenience. My prayer would be if it can come up tomorrow.
So what was the direction of this court? Because this report was called for.
Yes, Lord, kindly have order dated 18th of February.
what the accused
Oh, this.
is guilty of, my lord, not one, many things, my lord, including making false allegation, etc., my lord. Because this is a serious matter, my lord. But my friend is saying that matter may can be taken. I have no objection to that.
Tomorrow, my lord. It's all interconnected, my lord, these matters.
No, tomorrow.
The other matters listed tomorrow, my lord.
I know,
Bagna.
but we may not have time tomorrow. This court will not sit for long.
In that case, Monday, my lord.
We'll take it on Monday.
Monday, my lord. And tomorrow's matter also, my lord, we'll have to take it on Monday.
On payment by the counsel of the petitioner. This matter on Monday.
Read from me.
Deep.
Next Monday.
Deep.
Daily list, item number 1.
My lord, as per the verbal instruction on the last occasion, my lord, the petitioner was asked to find out the present status in the trial court below, as how many witnesses been examined. But it appears they are not here. We'll have it on Monday, my lord.
NDPS.
My lord. The only sole ground is that Section 50 has been violated, which is not applicable in this case. It was from the seizure was from the vehicle, not the person. So we'll have it on Monday, my lord. 1 and 2, my lord.
None appears for the petitioner. On pray made by Mr. R. Gurung Lanadji. List this matter on Monday.
Deeply obliged.
Monday, yeah. 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 No.
Deeply obliged.
Item number 2. Item 3.
So 3 to 5 are connected.
Made this lordship. Lordship, item 3, 4, 5 connected, your lordship. Lordship, I'm in this matter, your lordship. I would. Made business, your lordship. Lordship, in this matter also, I'm praying if the matter can be taken up on Monday, Your Lordship, and 3rd, Your Lordship. I just received the case diary, Your Lordship. I need to go through, Your Lordship.
Is a bail application?
Lordship, yeah.
What is
This
the
is
state?
the regular bail application.
My lord, I have been alleged to be a manager.
No, what is the stage of the case?
It's under investigation.
Pending investigation, Your Lordship.
Charge sheet have not been filed.
No, Your Lordship. I just received the case diary, Your Lordship. If Lordship permits me till on Monday, Your Lordship, I'll go through, then I'll place before Your Lordship.
I'm going to order
On
Monday.
Monday, Your
Mr. Kera?
Lordship. No, tomorrow I'm not coming. I have some personal difficulties. Monday, Your Lordship. Highly obliged, Your Lordship.
Obliged, lordship.
Item number 7.
Yes.
Your Lordship, today we are not ready with the matter. Maybe I'm seeking some time, Your Lordship. Need some time to prepare, sir.
It's a 2019 matter. If we go with sometime, then I don't know when will the time come for the matter to be finally disposed of. This is Assam Regiment School.
Yes, it is Assam Regiment School. At the end of the service of the petitioners, the issue goes to come forward and face the interview again after serving 23 years of service. So after 3 petitions, 2 retired already, only 1 remained. One remained. And notice was issued, the school filed the counter, and subsequently they did not appear. And pursuant to permission, I took a step again. Service was received, they did not come forward. And because of that, my lord, matter has proceeded. Earlier occasion, Mr. Rakhal, who represent for the Union of India, he sought time again and again. And now he is not there. The matter can be fixed one week or...
Yeah, 1 week. It's an old matter. Why should we delay unnecessarily?
Yes, yes.
You are also there, Mr. Devnath is here. Yes, Mr. Devnath, where were you?
So here I am only for the Union of India. Only I have given.
It's okay.
Yes.
You are for the Union of India, we'll take it.
So
that you are
here,
there.
so this when this
Because you have been, you see, all along you have sought instruction
so
as to whether you will also appear for the school. First you say yes, no, we don't know.
so not yet any information about it. So
we'll
here as a central government council, I can represent only for 4, but not others. But affidavit is there whenever filed. It is 4, 5, 7, and 8 together they file.
Who have filed?
This earlier my predecessors when filed.
Okay, on behalf of the
This, it is filed for also. This is the problem actually. That's regarding this clarification.
see,
also,
now you see, now if you have filed affidavit, joint affidavit on behalf of the union as well as the school, it's incumbent upon you to defend the parties. Now you are saying that you are no longer.
yes, you will see this problem rises here because this school is there under the society, and they are not part and parcel of the Union of India.
True.
But they have filed 2 affidavits. One affidavit filed by Union of India, and another affidavit filed by the school management. And that 2 affidavits were filed through the earlier standing council.
Yes.
And subsequently, they are not appearing. So
I
only my request is, my lord, Then the CGC do not represent the school also. Matter may fix within 1 week or 2 weeks.
Your
And
Lordship,
finally heard the matter.
Your Lordship,
Because he cannot say report. He cannot say that I'm representing for Union of India and he wants to refer the affidavit filed by the non-represented party. That he cannot do.
Your
It's
Lordship,
difficult to argue also.
I may be my
Yes.
learned
Yes,
brother
tell
is
me, tell me.
saying that there is two affidavit he is saying, Your Lordship. As per the documents which I received, Your Lordship, there is no two affidavit. This is the affidavit copy I just received from president, and then if he is having separate affidavit, if he kindly help me, then I can.
No, we are not talking. We see, we are not. We are here only to confirm whether the school will contest the matter or not. Having filed their affidavit
So,
through the CGC.
this my learned friend is saying that there is two affidavit, but I didn't get the two affidavit. I got only one affidavit, and it is 4, 5, 7, and 8. It is written. So this is the problem has come to me. That's why I was trying to confirm also, Your Lordship. If it is two affidavit, then I can stand on this my affidavit on list. Otherwise, I have to say this. I based on this affidavit. Then questions come up that it is when.
Well, I'm still corrected. Maybe it appears only respondent 4 to 8 has filed. That is school management only. The Union of India not yet filed.
Oh, school management.
Well, only school management has filed it, and they are not representing. And Union of India has so chosen not to file in that case. So better be fixed for final hearing, madam.
No, but Mr. Sangreso, we have to be very clear on this. Firstly, as to the stand of the council,
Yes.
the CGC. Earlier, he has been representing the
Yes, possible.
school.
Yes.
Then later on, he says no. But that, you see, that message has to come from the school that he is no longer a council.
Right.
In this regard, we have issued
We have issued
notices,
We filed a service report, service affidavit also.
but they have
They
not.
receive already and they are not coming forward. That means that they are not willing to contest the matter. It's all matter after 1 week or so. But better can dispose.
on pre-made by the direct senior counsel appearing for the petitioner. Matter is adjourned, let's say, after 1 week.
Item number 9.
Oblige.
Please, Your Lordship. Your Lordship, I seek for accommodation in this matter, Your Lordship, as the learned GSGI is on legs.
So, on pre-made by Mr. Laird Counsel appearing for the petitioner. None has appeared on behalf of the respondent.
No, Your Lordship, I can't find them.
Matter is adjourned. Matter is adjourned. It may be noted that none has appeared on behalf of the respondent. Just the matter up to. But kita kiwi mo, hindi ko
Obliged.
Item number 14.
My Lord, this matter we got the instruction. The petitioner was given the statement recorded by the police itself from Nagaland. So in view of the statement taken already, the issue of arresting him is not arise up now. So I pray matter may be closed as not pressed, my Lord.
on pre-made by the learned, my mistake, Sangresu learned senior counsel appearing for the petitioner to say that the matter is not pressed. This petition is accordingly dismissed as withdrawn.
Since my Lord, statement has been recorded,
That
that may
is
be reflected, my Lord.
why should I say? Why should I say? That
We
has
bring on record on
that
it.
has got nothing to do with this case. You have approached the competent authority. You have appeared there. Statement has been recorded.
Record.
So there's no question of what you have. Why you have come here is because of apprehension.
Apprehension.
If that is no longer an issue, then
Absolutely.
If there's anything else after that, it's up to you.
Obliged.
Second call from supplementary list, item number 3.
Yes, Mr. Jindal, where were we?
My lord, I just started taking, my lord, through the impugned judgment passed by First Appellate Court. That is at page 149. But just taking 20 seconds just to refresh what had happened prior. Lordship will kindly recall the dispute or the fight was between two lease deeds. One held by them, which they claim they entered into with us from 1914. In that lease deed, it was about 16 acres of land. Then their contention was that in 1923, a fresh lease deed of 10.19 acres was entered for only 10 acres of land, approximately. So again, their contention is that 6 acres was given back to them in 1923. So the first court, the first suit court, had found in our favor to the extent that, yes, we had a lease deed, valid lease deed from 1923. Number two, that lease deed was a perpetual lease deed. Our suit had been filed only for declaration that we hold a lease deed, a valid lease deed, and because we hold a valid lease deed, no one, the defendant should not disturb our possession. So that should have been the end of the matter, but the first suit court went on to dismiss my suit on the strange ground that there was an issue framed that did I object when apparently they had issued certain pattas to certain other people in respect of some land, which they claim is part of the suit land. That was not within my knowledge, the fact that they're going around issuing pattas. So the answer was obviously no. I did not object at that time.
That was not your relief sought, Namji.
It had no connection with the suit, my lord. It had no connection with the suit. So having found that I did not object, my suit was dismissed. After having found that, yes, indeed, I do hold a valid lease deed. And because of that lease deed, no one obviously can disturb my possession, my lord. So that was the first judgment that was passed against me. I filed the first appeal in the First Appellate Court. First Appellate Court, my lord, the judgment that was passed, it starts from 149 of the paper book.
Yes.
Now,
yes,
I had taken, my lord, through some portions of this judgment on the last occasion. But before I move forward, my lord, if I can draw lordship's kind attention to a provision of law, that is Order 41, Rule 31, my lord. Order 41, Rule 31 of CPC.
Order 41.
41, my lord. Order 41, Rule 31. In Lordship's volume, it will be page 271.
Rule 31.
Order 41, Rule 31. Page 271 in this book. (271), right at the bottom.
In which, in the paper book?
In Lordship's book, the Bear Act.
Is it your?
Oh, sorry. I thought it was the same.
This is universals. Yours is?
It's a different law and justice.
So I was slightly confused.
My mistake. Order 41, Rule 31. Lordship has.
Yes.
My lord. So Order 31, Rule 31, my lord, it lists out the duties of a appellate court, my lord. So I'll just quickly read Order 31, Rule 31, Rule 31, contents, date and signature of judgment. The judgment of the appellate court shall be in writing and shall state.
Yes.
And shall state A. Points for determination. B. Decision thereon. C. Reasons for the decision. And D. Where the decree appealed from is reversed or varied, the relief to which the appellant is entitled, and shall at the time that it is pronounced be signed and dated by the judge or the judges concurring therein. My lord, the stipulation of law is very simple. The appellate's court duty is to, when passing a judgment, is to determine the points for determination, to set out the points for determination, the decision on those points, on those precise points, and the reasons for the decision. Very simple, very logical, my lord. In the same connection, the Supreme Court was also pleased to expand on Rule 31 and to further list out the requirements of a appellate judge, my lord. That on an earlier occasion, my lord, I had submitted a small compilation. Yes, my lord. Of this compilation, my lord, page
Compilation
a small compilation
of judgments or
of judgments, my lord.
Because there are also relevant documents.
No, that's a different thing. This compilation, my lord, page 15.
50.
Oh, 15.
Yes.
Page 15, my lord, is a 2021 judgment, fairly recent, my lord.
Yes.
Para 7 of this judgment, my lord.
Yes.
My lord, the relevant paras are 7 to 10, 7 till 10. I'll just read para 7, my lord. I'll read para 7, please. In the present case, the original plaintiff instituted a suit for specific performance of the contract. On appreciation of evidence, the learned trial court held the issue of readiness in favor of the plaintiff, however refused to pass the decree for specific performance on the contract on the ground that the plaintiff was not willing to purchase the property with tenants. Therefore, the issue with respect to willingness was held against the plaintiff. In an appeal filed before the High Court under Section 96, same as us, our appeal, my lord, read with Order 41 by the impugned judgment and order, the High Court has allowed the said appeal and has quashed and set aside the decree passed by the learned trial court, dismissing the suit, and consequently has decreed the suit for specific performance. This portion is important, my lord. Having gone through the impugned judgment and order passed by the High Court, it can be seen that there is a total non-compliance of Order 41, Rule 31 CPC. While disposing of the appeal, the High Court has not raised the points for determination as required under Order 41, Rule 31 CPC. It also appears that the High Court, being the first appellate court, has not discussed the entire matter and the issues, my lord, I highlight this, and the issues in detail, and as such, it does not reveal that the High Court has reappreciated the evidence while disposing of the first appeal. It also appears that the High Court has disposed of the appeal preferred under Order 41 CPC read with Section 96 in a most casual and perfunctory manner. Apart from the fact that the High Court has not framed the points for determination as required under Order 41 Rule 31 CPC, it appears that even the High Court has not exercised the powers vested in it as a first appellate court. As observed above, the High Court has neither reappreciated the entire evidence on record, nor has given any specific findings on the issues which were even raised before the learned trial court, my lord. So, my lord, very settled requirement of law, my lord. As a first appellate court, points for determination have to be framed. Then the entire evidence has to be reappreciated. Having reappreciated the entire evidence, the specific findings on the issues which were raised before the trial court, so the issues framed by the trial court, the suit court, have to be reconsidered or re-adjudicated after reappreciating the entire evidence, my lord. question before this honorable court would be, has the first appellate court done this in this case? Perusal of the impugned judgment will show no. There has been an abject failure on the part of the first appellate court in the impugned judgment to conform to Order 41 Rule 31. No points for determination have been framed. The issues raised before the lower court, the suit court, they were not touched upon. Evidence was not reappreciated. Nothing happened. What happened, my lord? I'll quickly take my lord through it. Page 149, the judgment starts. Now, on the last occasion, I had pointed out that on the first page itself,
Yes.
149, my lord.
Yes.
The first portion, my lord, lordship will see case of the plaintiff in the suit.
Yes.
So what learned first appellate court has done is, it has copied my suit, my plaint. So word for word, my plaint has been copied in the next few pages till, my lord, page 156. So whatever I had stated in my plaint, very faithful reproduction of the plaint is there in this judgment. Page 156. Everything in my plaint has been copied, including the schedule of the land also. Then case of the defendant in the suit, page 156. The WS has been copied in toto, word by word has been copied, my lord. This again goes on till page 159. 159, my lord, the issues that were framed by the first court, that has been reproduced, my lord. Next page, my lord, 160. Evidence adduced by the parties. Now, lordship will kindly recall the mandate of the Supreme Court and Order 41 Rule 31. Evidence has to be reappreciated. What has happened here? Evidence adduced by the parties. Appellant Plaintiff Club examined Shri so-and-so as PW1, while respondent defendant so-and-so examined himself as DW1. In addition, on the prayer of the respondent defendant, the additional director of survey also submitted a report dated so-and-so. This is the sum total of the evidence. So I produced one witness, they produced one witness, that is all that is reflected. Next, my lord, judgment passed by the learned trial court. Just a two-line summary of the judgment, that my suit was dismissed by the first court's judgment. Then, my lord, the next heading in this judgment, grounds of appeal. Now, grounds of appeal, my lord, again, the grounds that I had taken,
Yes.
the grounds that I had taken in my memo of appeal,
Yes.
again have been faithfully reproduced, copied word for word, my lord. And this reproduction, this copying has gone on till 162, my lord. Till para Roman 12, my lord. And para 44 is where it would appear that the first appellate court starts some sort of analysis or discussion. But no, I'll read my para 44. I have heard submissions of the counsels of the parties and perused the case record. Counsel of the respondent defendant relied on the following decisions. Decisions have been listed out. Now, these are decisions relied on by the defendant. Where are my judgments, my lord? There is no reflection. I have submitted several judgments. Next page, my lord. Page 163. Points for determination. So this again is a requirement under Order 41 Rule 31.
Yes.
Stipulated by the Supreme Court. Now, what is the point for determination that is framed by the First Appellate Court? Para 45.
Yes.
The question that is required to be answered is whether the impugned judgment dated 23/12/2015 is sustainable in facts and law of the case. This is his point for determination. I know this is, with all respect, I have to point this out. This is a generic point, my lord. I have filed an appeal challenging an order. So whether the order is correct or not is obviously what the First Appellate Court has to decide. But as a First Appellate Court, you are required to go one step or few more steps and determine or frame points for determination. He frames with respect again. No point for determination. This is not, I would say, this is not a point for determination. This is a point in every appeal. Whenever an appeal is filed, the first or the basic fundamental question is whether lower court's order is correct or not. That is not a point for determination. Cannot be a point for determination. So no points, no appreciation of evidence, no points for determination. Then it goes on. Para 45. Again, some sort of analysis has been attempted. It appears, but again, no. Para 46. To understand the rival contentions, let us discuss the evidence on record. Now, again, with respect, I have to point this out again. Para 47 onwards, PW1 Parambir Singh, in his examination in chief, he deposed that Learned First Appellate Court has again copied the examination in chief, which was submitted on an affidavit. Word for word, it is again copied. So, para 46, First Appellate Court says, let us discuss. No discussion. It is just a control copy-paste job that has been done till, my lord, page 167. So the chief has been copied till para 61. That is at page 167. And the records are available. Simple comparison will suffice to show there is obviously no discussion. It is just a copy of the chief.
Yes.
Then para 62 onwards.
Yes.
Para 62 onwards.
Yes.
Para 62, during cross-examination, PW1 Shri Parambir Singh testified that he has been a member of the club. The cross-examination has now been copied. So again, no attempt whatsoever at any discussion or anything. It is again a pure copy of the cross-examination of PW1, my lord.
So you mean to say that even from para 62 to?
So till 61, my lord, the chief was copied. Till 61. From 62 onwards, the cross is copied.
Cross is copied.
Yes, my lord. And one para from the cross, that is para 69, page 168. Para 69.
Yes.
I'll quickly read, my lord. One.
Yes.
Para 69, he was not aware, that means my witness, was not aware of the location of original document dated 20th March 1923, and he did not produce before the court. It is, however, in their possession. So, why I'm highlighting, my lord, will appreciate once I come to the end of this judgment. This paragraph shows that I admitted that because I had marked my lease deed as a paper mark, not as an original exhibit. But
you are required to produce the original, isn't it?
Yes, my lord. The importance of production of original would arise if there is a dispute regarding that document. Now, this document, there is no dispute. Like I had highlighted, there is no dispute between the parties about the existence, validity of this document.
It comes within the realm of admitted facts.
Admitted facts. Section 58, my lord. So, in any event, this was required to be highlighted. If Lordship turns the page 169, having copied the cross-examination of PW1, now para 72.
Yes.
Para 72.
Yes.
DW1 Shri Asir Sham, thank you, in his examination. Now, First Appellate Court copies the chief examination of DW1. Word for word again. Till next page, my lord, para 77. So till para 76 is the chief of DW1. Para 77.
Yes.
In cross-examination, DW1 Shri so and so. Now the cross of DW1 is there. The cross is copied.
Okay. Copied word by word, word for word.
Word for word, my lord.
Okay.
Maybe with some grammatical changes here and there, but word for word, I would say.
Para 77 is the cross.
Cross of DW1. So I'll just pause. The requirement of law is reappreciate the evidence. what has First Appellate Court done? Copied the evidence. Does that render the impugned judgment as inadequate in law? I would say it does, my lord. I would say it does. On the same page, my lord, page 170, Lordship will see in the middle, discussion, decision, and reason thereof. Now, there is discussion here.
Yes.
Now, I have to admit there is discussion. But there is discussion on non-issues, issues which are not even present in the case. If Lordship allows me to explain why I say this. Para 78, my lord. At the outset, it may be stated that the plaintiff appellant in the pleadings, that is my plaint, stated that the Shillong Club Limited is a company registered under the provisions of the Companies Act 1956 and it has its registered office situated at so-and-so. But PW1 Shri Parambir Singh, who is the director of Shillong Club Limited, in his cross-examination deposed that he cannot tell before the court where is the actual location of 6.72 acres of the main course of 6.72 acres of the main concern of the club in the area of 10.19 acres. It is not a fact that the 6.72 acres is situated to the south of the clubhouse. It is a fact that in the plaint as well as in his evidence in chief, it is admitted that the club had taken on lease a plot of land from the predecessor of the defendant, 79. In his cross-examination, PW1 Shri so-and-so further stated that I have stated in my examination in chief that the Shillong Club was incorporated a limited company and registered under Companies Act 1913 only on so-and-so. It is a fact that the Shillong Club does not know that particular firm or constitution by the name and style of Shillong Sports Club. It is also a fact, as stated in his examination in chief, that the lease deed dated 20th October 1914, which is Exhibit A, is not related to the club in any manner. Next, my lord. The pleadings of the appellant, plaintiff company, and the evidence of PW1 is contradictory to each other with regard to an issue of the formation of the plaintiff appellant company. I'll just pause, my lord. I'll in fact finish the next line. That there is no certificate of the incorporation of the plaintiff appellant company produced before the court to prove as to whether the plaintiff appellant company is a registered company under the Indian Companies Act 1913 or under Companies Act 1956. So, the first appellate court, the first issue it thought necessary to examine is my existence, my corporate personality. Whether I was so apparently in my pleadings I have stated I am registered under 1956 Companies Act. Again, apparently in the cross, my witness has stated I am registered under 1913 Companies Act. So the first appellate court says that there is a contradiction in this. Now, this is not an issue, my lord. Whether I was registered under 1913 or 1956 or any other iteration of the Companies Act, it is not an issue, my lord. My existence as a company is not under challenge. No one is questioning my existence as a company. But the first appellate court makes a big deal, makes a big hue and cry about this even later in this judgment, my lord. So, as far, but just to address this issue, this apparent contradiction, there is no contradiction. On record, I was incorporated in 1923. So, if I was incorporated in 1923, obviously I was registered under 1913 Act, not under, could not have been under 1956 Act. Now, even though I was registered in 1913 Act, I am still to be considered as a company registered under 1956 Act. That is, my lord, because of section 656 of the 1956 Companies Act.
The old act having been repealed.
So even if the old act is repealed, what 656 of 1956 Act says is, even if the old act is repealed, it is considered that I am registered under the new act. So I mean, I will not spend any much more time on this. This is not an issue, my lord. So learned first appellate court had no occasion or no reason to go into this aspect, my lord. Next paragraph, my lord. Para 81. That it is not known whether the appellant plaintiff company is a company limited by share or limited by guarantee. Again, with respect, my lord, whatever respect I can summon, where is the necessity of examining whether I am limited by shares or by guarantee, my lord? There is no requirement. I'll just continue reading, my lord. It is a settled principle of law that an incorporated company has a separate existence and the law recognizes it as a legal person separate and distinct from its members. This new legal personality emerges from the moment of incorporation, and from that day the persons subscribing to the memorandum of association and other persons joining as members are regarded as body corporate or corporation aggregate, and the new person begins to function as a new entity. A corporate personality is a reality and not an illusion or fictitious construction of the law. This may be true, but it has no place in the proceedings, my lord. This is a refresher course on basics of company law, my lord. Where is the necessity or where is the importance of this? There is no place, there is no importance of these principles having been reflected in the impugned judgment. Next paragraph, my lord. Para 82. Yes. From company law, learned first appellate court jumps to Evidence Act. Without any context. What happened to company law issue? We are not sure. But para 82, suddenly Evidence Act section 101 comes. Burden of proof. Burden of proof 101. Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that these facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Illustrations are there. I'm not reading everything, my lord. I agree, my lord. Yes, burden of proof is 101 imposes a burden on a person who says that this is the truth. I have to prove my assertion, my lord. It is common knowledge, my lord. It is common knowledge. Moving on, next page, my lord. What happened to burden of proof? Again, we are not sure. Middle of next page, para 83.
Yes. Para
83, my lord. So 82 was burden of proof. He reproduces section 82.
Yes.
Then para 83. Para 83. In Rangamani versus so-and-so and another, 2011, it was held as follows. There is nothing. What has held? Supreme Court has held what? Who has submitted this judgment? There is something missing out here. Para 84. Union of India and others versus so-and-so housing society. The legal position, therefore, is clear that the plaintiff is in a suit for declaration of title and possession could succeed only on the strength of its own title, and that could be done only by adducing sufficient evidence to discharge the onus on it, irrespective of the question whether the defendant had proved the case or not. We are of the view that even if the title set up by the defendant is found against, in the absence of establishment of plaintiff's own title, plaintiff must be non-suited. It may be pertinent to mention that both parties admitted that there is a lease deed dated 20th March 1923. This is very, very crucial. First Appellate Court himself admits and puts it in the judgment that both parties have agreed that there is a lease deed dated 1923, my lease deed, of 10 acres.
Yes.
Executed between the appellant plaintiff club and the respondent defendant, where a perpetual lease was granted by the respondent defendant to the plaintiff appellant club over an area of 10.19 acres with effect from so and so. Now, next paragraph, my lord. 86.
Yes.
The reason I'm reading most of these paragraphs, my lord, is just to highlight the thought process, the chain of thoughts of the learned First Appellate Court. It seems to be, with respect, my lord, a little scattered. First, Companies Act, then burden of proof 101, then now we come to some other issues, my lord. 86. Plaintiff Appellant Club relied on the registered lease deed dated so and so, and the same was marked as paper mark 1, but during cross-examination, PW1 Shri so-and-so testified that he was not aware of the location of original document dated so-and-so and he did not produce before the court today. It is, however, in their possession. 87. Similarly, respondent defendant also relied on lease deed dated 20th March 1923 and the same was marked as paper mark A. However, the DW1 Shri so-and-so in his evidence deposed that the duplicate copy of the lease deed dated 28th March 1923 and the original registered lease deed is in the possession of the plaintiff. Very well, my lord. It's neither here nor there, my lord. Para 88 is where the real problem starts, my lord. I'll read, my lord. It may be pointed out that in the vast tracts of land which was leased out to the appellant plaintiff club by the defendant respondent is situated outside normal area of Shillong, and it falls under the Assam Frontier Tracts Regulation of 1880 at the time when the lease deed dated 20th March 1923 was executed. The said tracts of land was declared as a backward tract by notification published in 1929 under the Government of India Act 1915 to 19, where it is stated that the laws shall not apply to the said territories or any part thereof, or shall apply thereto to such exceptions and modifications as the governor may think fit. So I'll just pause, my lord. Suddenly, it was no one's case, my lord. No one relied, referred, or quoted or extracted Assam Frontier Tracts Regulation 1880. So Learned First Appellate Court comes up with this thing called Assam Frontier Tracts Regulation and says that under this, some notification was published in 1929, which said that laws, regular laws, will not apply to the backward areas. Now, after referring to the Assam Frontier Tracts, I'll come back to Assam Frontier, my lord, but para 89.
Yes.
Para 89. In view of the said notification noted above, the Transfer of Property Act 1882 is applicable only within the territorial jurisdiction of the Shillong Municipality and Cantonment. The Transfer of Property Act 1882 has not been declared to be in force outside the normal areas of Shillong at the time when the lease deed dated 20th March 1923 was executed between the parties. The lease deed dated 20th March 1923 is not a valid lease deed, as the Transfer of Property Act 1882 is not in force in territorial jurisdiction where the landed property is situated. Further, on perusal of lease deed dated so-and-so, 23, relied by both the parties, that was executed between so-and-so and General Secretary Sports Shillong Club from the said lease deed dated 1923. It is clear that the appellant plaintiff Shillong Club Limited is not a lessee of lease deed dated 20th March 1923. There is no evidence on record adduced by the appellant Shillong Club as to how the said landed property mentioned in the lease deed dated 1923 was transferred from the General Secretary Sports Section Shillong Club to the appellant plaintiff Shillong Club Limited. I'll just pause, my lord. There are three things that have to be addressed, my lord. Now, firstly, this Assam Frontier Tracts Regulation that First Appellate Court has come up with. Lordship may recall on the first day of motion of this particular matter, before my lord, I had said that we are not aware, we could not even locate at that time, this Assam Frontier Tracts Regulation, my lord. Subsequently, my lord, after much effort, we did locate this Assam Frontier Tracts Regulation. It's a one-page document which we found somehow in this Justice Ansari's 6th schedule book, my lord. Now, I'll read, my lord. I'll read from Regulation 1, my lord. This regulation may be called the Assam Frontier Tracts Regulation. It extends to such frontier tracts within the territories for the time being administered by the Chief Commissioner of Assam, as he may, by notification in the local gazette from time to time, direct. And it shall come into force in each and such tracts on such day as he in like manners directs in this behalf. Para 2. Powers to direct enactments shall cease to be in force. When this regulation has been extended in manner hereinbefore prescribed to any tract, the Chief Commissioner may from time to time, by notification in the official gazette, direct that any enactment in force in such tract shall cease to be in force therein, but not so as to affect the criminal jurisdiction of any court over European British subjects. Regulation 3, not very important, settlement of boundaries, question of boundaries. So, my lord, what I can see from Regulation 2 is that this regulation has empowered the Chief Commissioner of Assam to declare by notification in the official gazette that even if there is a law in force, after notification, that law will not be in force. So, first requirement is that there should be a law in force. Then, if Chief Commissioner so decides, he can issue notification saying that this law will no longer be in force in that backward tract, my lord. That is what I can make out from Assam Frontier Tracts. But does it mention anything about transfer of property, etc.? Nothing, my lord. At least the regulation. Then in the impugned judgment, First Appellate Court had referred to some notification published in 1929. Again, after much effort, we located this notification, the next page,
Yes.
which may be the notification which, because it says Assam Government Handbook 1929.
Yes.
But does this notification have any bearing on the matter? I would say no, my lord. I'll just quickly read. In exercise of the powers conferred by subsection 2 of section 52A of the Government of India Act, the Governor General in Council is pleased to declare the territories in the province of Assam, which are specified in the schedule hereto annexed, to be backward tracts, and further within the sanction of His Majesty, which has not been signified by the Secretary of the State in Council, to direct that in the said Act, in its application to the said territories, shall be subject to the exceptions and modifications specified in the second column of the said schedule. Further, in exercise of the like powers, the Governor General in Council is pleased to authorize the Governor of Assam in Council to direct that any act of the local legislature of Assam shall not apply to the said territories or to any part thereof, or shall apply thereto, subject to such exceptions or modifications as the Governor may think fit. I'll just pause again, my lord. So, the Governor General, the Governor of Assam, under this notification, it appears the Governor of Assam has been given the power to direct that any act shall not apply to the backward tracts. If Lordship looks at the schedule just below,
Yes.
Lordship will see that the serial number 2,
Yes.
British portions of the Khasi and Jaintia Hills district, other than Shillong municipality and cantonment, has been declared as a backward tract. Very well, my lord. It has been declared as a backward tract. But does that automatically mean that the laws in force will not apply, my lord? No. This notification says that the Governor of Assam has been given the power to direct. He has to direct it. He has to direct that any law that is applicable will not be applicable. Similarly, under the frontier regulations, the Chief Commissioner may notify in the official gazette that any enactment which was already there shall no longer be in force, my lord. Is there any reflection of Transfer of Property Act out here? Nothing. Neither in the notification, neither in the regulations, my lord. So, on what basis does the learned First Appellate Court say that there is this regulation, there is this notification? That means it shows that Transfer of Property Act does not apply, my lord. Transfer of Property Act did apply at that time in 1923. Transfer of Property Act applies till today, my lord, and there cannot be any dispute in that. If there is a question, or if it is held that transfer of property did not apply or does not apply, I need not point this out, it will lead to chaos, my lord. So, reliance placed by the learned First Appellate Court on this regulation and the notification was misplaced for several reasons. First, it was nobody's case. Second, even notwithstanding that it was nobody's case, courts have the power to pick up laws and apply it in certain situations. But there is no application of this regulation or the notification in the circumstances of this case, my lord. So I would say my first point would be that the foundation of this judgment, founding itself on this regulation and the notification, is I will not even call it a weak foundation. It is a non-existent foundation, my lord. There is no foundation, my lord. So his finding that on the relevant date in 1923, Transfer of Property Act did not apply, therefore your entire lease deed is invalid. Lordship, I fail to find the words to express my true surprise at this, because as I said, there is no dispute between the parties as to the existence and the validity of the 1923 lease deed. None of the parties have, especially the defendant, has not requested the First Appellate Court to declare it as invalid, etc. What I had pointed out day before yesterday also is very crucial. At the time when I filed the suit, no counterclaim was filed. At the time when I filed the appeal, no cross appeal was filed. So the the defendants did not make any claim before the first appellate court. That being the case, having found that my 1923 document, the complete document, was invalid, what is the result, my lord? The result is, defendant had a claim of 6 acres. Because of this judgment, instead of 6 acres, the defendant gets the entire land back. That cannot be, my lord. Defendant firstly has not raised any such claim. I have not been given an opportunity to meet such claim. And this finding itself is based on incorrect premises, my lord. Regulation and that notification, my lord. That is the second point. The effect of this judgment, my lord, cannot be condoned by this honorable court. Thirdly, in para 90, again a surprising conclusion. What does he say, my lord? There is no evidence on record adduced by the appellant plaintiff Shillong Club as to how the said landed property mentioned in the lease deed dated 1923 was transferred from General Secretary Sports Section Shillong Club to appellant Shillong Club. So para 90, again a very surprising observation, that I have not produced any evidence as to how the person who signed the 1923 document transferred the property from himself to the Shillong Club. Now, my lord, just to understand what exactly may have been going on in the mind of the first appellate court, if lordship looks at the document itself, that is at page 23, I think, 1 minute, page 14, my lord, of the compilation.
Yes.
That's my 1923 lease deed. The last page may be looked at, my lord. Page, that is at page 16, 16. Last page, page 16, right at the bottom, the signatory may be looked at, my lord, on the right hand side of the document.
Yes.
Last page 16,
Yes.
right at the bottom, right hand side, there is a signature of some person, my lord, General Secretary, Sports Section, Shillong Club. So this signatory, the person who signed this document on behalf, yes ma'am,
Okay.
page 16, right at the bottom, right hand side. Left hand side is the defendant's signature, I assume.
Yes. Yes.
Right hand side is General Secretary, Shillong Sports Section, Shillong Club. So Mr. So and so, whoever that may have been,
Yes.
in his capacity as General Secretary
Yes.
of Shillong Club, has signed the document.
Yes.
Now, First Appellate Court in para 90 is saying it is not clear, there is no evidence as to how General Secretary transferred the land to Shillong Club. My vocabulary is inadequate to address this issue, my lord. Agreements on behalf of companies are signed by directors,
No, I
managers.
think there's an apparent, I don't know, could be some confusion
Yes, ma'am.
as to the entity involved, the Shillong Club,
Yes,
or the Shillong Sports Club.
Yes, my lord. So that question was answered, my lord, by the first court. So in the first court, if lordship recalls, the contention in the WS was that in 1914 they entered into a lease deed for 16 acres with somebody, with us. The finding of the first court on issue number 3 was very clear, my lord, that the 1914 document was entered into with an entity called Shillong Sports Club, which is different from Shillong Club. If I can take, my lord, to the finding.
But this is wrong.
No, because if lordship sees the document of 1923, page 16,
Yes.
it says General Secretary, Sports Section, page 16, my lord.
Yes. No, let's-
General Secretary, sports section, comma, right at the bottom, you know.
Yes, yes.
Page 16.
True. Shillong Club, yes.
So General Secretary, sports section, comma, Shillong Club. So Shillong Club has many sections: swimming section, tennis section, golf. I'm not very aware what other sections. The sports section's General Secretary has signed on behalf of the Shillong Club Limited. So, the first suit court had come to a very categorical finding, which is not challenged, my lord. It still holds.
Is there an entity called the Shillong Golf Club?
No, my lord. It is the Shillong Club, because Shillong Club is the, I will not say owner, is the lessee of that golf course. So it runs the golf course by itself. So there is no golf club, Shillong Golf Club. There is a private club run by some other persons. They hold training sessions and all that. That is a separate entity. I'm not sure what the name is. It could be Shillong Golfers Association. Something of that is there. But there is no separate entity called Shillong Golf Club, to my knowledge.
Hey, this is not in dispute.
It's not in dispute, my lord. It is not in dispute, like I said right at the beginning many times.
As far as the trial court is concerned.
As far as trial court is concerned, trial court was, my lord, very clear that 1914, they executed a document with someone called Shillong Sports Club.
Okay.
And finding is again very clear, which is different from Shillong Club. That finding has not been assailed till today, either by cross appeal or any other means. So that finding has crystallized and holds good, my lord. So that finding could not have been shaken by the First Appellate Court in the absence of a cross appeal. Now, First Appellate Court, my lord, what I was highlighting is, has observed that there is no proof as to how General Secretary transferred the property to Shillong Club. Now, my lord, it is a fact of life, it is a fact of everyday life that when a company enters into an agreement, a company is a juristic person. Company cannot sign an agreement. Somebody on behalf of the company signs the agreement, either a director, an authorized representative, an agent, a manager, whoever has the authority to sign, signs on behalf of the company, my lord. Once that person has signed on behalf of the company, that person is not required to once more enter into one more agreement with the companies transferring the property to the company. The moment he has signed on behalf of the company, that agreement is deemed to have been signed by the company itself. It's a very basic position, my lord. But the learned First Appellate Court says, where is the proof that General Secretary of the Shillong Club transferred the property to Shillong Club? No proof is required. General Secretary signed on behalf of Shillong Club, my lord. Now, moving on, my lord, page 174 again.
Yes.
Para 91, my lord. Lease deed dated 1923, relied by both parties. Repeatedly, my lord, First Appellate Court refers to the fact that both parties are relying on the same document. Nevertheless, relied by both parties is not a primary evidence as defined under Section 64 of Evidence Act. It is seen that during cross-examination of PW1 Shri so-and-so, deposed that he was not aware of the location of original document dated so-and-so, and he did not produce before the court. It is, however, in their possession. From the evidence of PW1 Shri so-and-so, it is clear that the lease deed dated 1923 was in the possession of the appellant plaintiff club. However, no reason was assigned as to who has prevented the plaintiff from producing the original lease dated 1923 before the court as prescribed under Section 65 Evidence Act, where secondary evidence relating to documents may be given. Hence, adverse inference is to be drawn against the appellant plaintiff for non-compliance with the provisions of law. Next paragraph, my lord. In view of these discussions, reasons stated above, this court is of the opinion that appellant plaintiff has failed to establish their case that they are the lawful lessee in respect of the suit property. Now, taking it one step at a time, my lord. First, the lower court, my lord, refers to the fact that I did not produce the original. As lordship had himself noticed some time back, if something is not in dispute, a document is not in dispute, there is no absolute necessity to produce the original. A paper mark can also be produced, which we did. Secondly, my lord, First Appellate Court refers to Section 65 of the Evidence Act. Now, Section 65 is regarding secondary evidence, my lord. If Lordship allows. Section 65 of the Evidence Act, the old Act.
Evidence Act has not been changed or
It has been, but at that time when the impugned judgment was passed, it was still this old Act.
now what do we have?
Now we still have to go back to the old Act, my lord, because old Act has been referred.
No, I'm talking about the present. Irrespective of this case.
Yes, my lord. We have the new Evidence Act, my lord.
New Evidence Act.
Yes, but I cannot pronounce it. It's a little difficult. Section 65, my lord. Evidence Act.
Or the Evidence Act.
Old Act.
The IPC.
IPC.
And the CRPC
have been replaced, my lord. Have been replaced. But nevertheless, we still have to open the old Evidence Act because First Appellate Court referred to the old Act.
That's true.
So Section 65.
Yes.
Speaks of secondary evidence, cases in which secondary evidence relating to documents may be given.
Yes.
Secondary evidence may be given of the existence, condition, or contents of a document in the following cases. I'll skip the first, clause B, my lord.
Yes.
When the existence, condition, or contents of the original have been proved to be admitted in writing by the person against whom it is proved or by his representative in interest. So, about the existence, condition, or contents of a document, I can give secondary evidence against a person in respect of the document when that person has admitted in writing about the existence of that document. Now, in the WS, on the last occasion I had pointed out, they have admitted that they entered into a 1923 lease deed with me. So once he has admitted in writing that he has entered into a certain 1923 lease deed, I am allowed under Section 65 to give secondary evidence about the existence or the contents of that document, my lord. So which I have done, which I have done through my witness and through the fact of having marked it, produced it as a paper mark, my lord. Now, the conclusion, my lord, para 93, that in view of the above discussion, reasons stated above, the court is of the opinion that plaintiff has failed to establish their case, that they are the lawful lessees in respect of the suit property. So, the discussions and reasons above, lordship has seen, what are the discussions and reasons? First, reason given is general, the Assam Frontier Tracts Act, read with that notification, shows that transfer of property was not in effect at that time. The regulations or the notification does not say that. It only provides for a situation where a certain law may be declared to be not in force. Has TP Act been declared not to be in force? There is nothing in the regulations and the notifications. First reason that has been given. Second reason that has been given is that I did not produce the original of the document, and I have only relied on secondary evidence, etc., my lord. That is enough, my lord. That is enough discharge of my obligation under the Evidence Act, my lord. Since it is an undisputed document, Section 58 of the Evidence Act also does not require me to produce evidence in respect of that particular document, but nevertheless, I have produced the document by way of a paper mark, my lord. So, my lord, this is the judgment. This judgment, my lord, was assailed by us in this second appeal. On the first day of motion, this Honorable Court itself was pleased to formulate the questions of law. The questions of law formulated, my lord, were two questions.
Yes.
First question, my lord, was whether a first appellate court can grant relief to the respondent in the appeal in the absence of a counterclaim cross appeal. Why this question was relevant or important was because of the fact that the first appellate court had declared my entire lease document, lease deed, as invalid. The claim was for, so the effect of that declaration is that the portion of 10.19 acres which I held till date for the last 1 century as a lessee, that portion comes under threat. Threat in the sense that now the defendant, the other side, is very well entitled to stand up and say your possession is invalid because learned court has declared your document on the strength of which you have possessed this portion as invalid. So their claim was for 6 acres. They have been given 10.19 acres, my lord. So the question framed very rightly, I would say, by this honorable court was, they have not filed an appeal. They have not filed a counterclaim firstly. Even not having filed a counterclaim, when they saw that the finding of the first court, the suit court, was against them in respect of the 1914 document. Suit court declared 1914 document is with some other person, not related to this case. They did not appeal that also. So they did not file a counterclaim, they did not file a cross appeal. But at the end of the proceeding, they have been given everything. The entire portion of land, not just 6 acres, 10.19 acres has been given. So the question was whether a first appellate court can grant relief directly, indirectly to a party who has not even asked for that relief, my lord. First question, in this connection, if lordship allows me.
Degree has not been drawn up.
My lord.
The degree has not been drawn up.
No, my lord. Decree has not been. No, as far as I'm aware, because the very next day we filed the appeal. Okay. Records must have been called at that time itself. In this connection, my lord, regarding the first question of law.
What is the decretal order of the first appellate court?
I'll just point it. Page 174, my lord. Page 174, right at the bottom, my lord.
Yes.
Order. In the result, in the backdrop of the discussions and reasons noted above, this instant appeal is hereby dismissed. Parties to bear their own cost, send back the trial case along with a copy of this judgment. Case stands disposed of on contest, given under by so and so. That's all. So there is no express declaration in their favor, but the effect of the judgment is important, my lord.
Oh, okay. Oh, sorry. I missed the point.
Yes, ma'am. There is no express.
It's the plaint that was dismissed.
The plaint was dismissed. The plaint was dismissed. So in the context of the first question of law, whether appellate court could have granted relief in this manner without the relief having been asked for at any point, if lordship kindly looks at the compilation of judgments, page 15 of this, page 9 of this compilation, my lord.
Now you will go on to discuss the judgments.
Yes, my lord. I will just wind up by discussing the questions of law, that's all. Read with the judgments.
How long will it take?
About 10 minutes, at least 10-15 minutes.
Yes, I may have to sit in TV.
I know. I'll try to be quick about it. Page 9 of the compilation, my lord.
Page
9. Page 9. It's a 1996 Supreme Court judgment. Para 7 of this judgment.
Yes.
I'll read quickly, my lord. Para 7. It is settled law that the right to claim preemption must be available on the date of sale, the date of suit, and the date on which the decree is passed. In so-and-so versus so-and-so, this court has held that when appeal against a decree is pending, the Court of Appeal has cessation of the whole case and the whole matter becomes sub judice again for certain purposes. That is execution, the decree is regarded as final. The decree of the trial court gets merged with the decree of the appellate court. Therefore, the Court of Appeal shall have all the powers and shall perform as nearly as may be the same duties as are conferred and imposed on the court of original jurisdiction. When the appeal, therefore, is pending in this court, it is a continuation of the original proceedings and the entire issue is at large, my lord. So, this judgment, very well-known proposition of law, appeal is a continuation of the suit. This judgment acquires importance in view of the judgment or the law laid out in the judgment at page 12, my lord. So in the suit, they did not ask for anything.
Yes.
Now, when appeal was filed, it was considered to be the same suit. They could have filed a cross appeal, if nothing else. Nothing was done. Now, page 12, it's a 2022 judgment.
Yes.
Lordship may remember this judgment. It was placed in some other context. Para 16 of this judgment.
Yes.
Coming to address the second issue, while this court is not apathetic to the predicament of the respondent grandparents, it is a fact that absolutely no relief was ever sought by them for the change of surname of the child to that of first husband, son of respondents. It is settled law that relief not found on pleadings should not be granted. If a court considers or grants a relief for which no prayer or pleading was made, depriving the respondent of an opportunity to oppose or resist such relief, it would lead to miscarriage of justice. In the case of so-and-so versus so-and-so, this court considered the issue as to whether relief not asked for by a party could be granted, and that too without having proper pleadings. The court held as under, it is well settled that the decision of a case cannot be based on grounds outside the pleadings of the parties, and it is the case pleaded that has to be found. Without an amendment of the plaint, the court was not entitled to grant the relief not asked for, and no prayer was ever made to amend the plaint so as to incorporate in it an alternative case. In the case of so-and-so versus so-and-so, it was held, though the court has wide discretion in granting relief, the court, however, cannot, ignoring and keeping aside the norms and principles governing grant of relief, grant a relief not even paid for by the petitioner. So, my lord, well-known proposition again. If something has not been asked for, that thing cannot be or should not be granted, my lord. Till today, a claim has not been raised by the defendant, by the respondents. But the effect of the First Appellate's Court is to grant them an unasked for claim. In the WS, they spoke of 6 acres. First Appellate Court might have said 6 acres is too less, take the entire property. By rendering my lease deed as invalid, or by declaring it as invalid when no one disputed the validity of that lease deed, the First Appellate's Court judgment has had the effect of granting a relief not asked for, my lord. So therefore, this question of law becomes important. It has to be answered by this Honorable Second Appellate Court holding. The First Appellate Court could not have granted a relief to the respondent in the absence of any counterclaim, in the absence of any cross appeal, my lord. So that is regarding the first question, my lord. The second question framed by this Honorable Court is whether the provisions of the Transfer of Property Act have no application over the tribal areas of the state of Meghalaya in view of the operation of the Assam Frontier Tracts Regulation 1880. Because this is the specific finding of the First Appellate Court. Because of the presence or the operation of Frontier Regulations of 1880, the TP Act does not apply to the tribal areas, including the suit property. So that was the second question framed. Now, my lord, I have already spent time on the regulations. I have already spent time on the regulations to show that regulations nowhere state anything about TP Act. It is a very general kind of regulation authorizing the Chief Commissioner to issue a notification, etc., my lord, to declare that a particular existing law will not apply in a certain area. The notification of 1929 again does not speak of the Transfer of Property Act. It says East Khasi Hills, etc., is a backward tract. Very well, it may be, but nothing to show that TP Act has been made inapplicable or was not in force in 1923 on the date of my lease deed, execution of my lease deed. So, my lord, just to quicken up things, I'll just draw lordship's attention to page 19. There is a judgment of the Supreme Court from 2012. This is in the context of this Frontier Tracts Regulation of 1880, read with that notification.
Yes.
Through this judgment, my lord, I am highlighting what is known as the principle of destitute, my lord.
Yes.
Now, the principle of destitute, if I am allowed to sum up in my own words, is a very simple principle. It says that if there is a law or an enactment or a statute which, for whatever reason, has not been in vogue or in use for a very extended long period of time, then it is considered to have died a natural death on account of disuse. That is the principle of destitute explained by the Supreme Court in this judgment at para 201, my lord. Next page. I'll just take 20 seconds, my lord. Just 201. 201.
Yes.
From the above, yes, Lordship has to leave.
So we'll continue after 1 week. Heard Mr. Sindel, counsel for the appellant. Hearing to continue after 1 week.
Almost finished. 5 minutes.
Almost completed.